My name is Michael Fallings. I am the chair of our firm's federal labor and employment practice. I am also a managing partner at our firm. I primarily focus on representing employees in the federal and private sector, including before the MSPB and the EEOC and the Office of Special Counsel and the state and federal courts. My bio is on the screen here, so you can learn a little bit about me. But let's go ahead and get started so we could discuss the shutdown and its implications. So specifically what we're going to discuss today, these topics really just about the shutdown and the continuing resolution that was signed by the president and passed by Congress and its impact on federal employees and how that impacts federal employment and how the shutdown impacts employees and their furloughed status when they're furloughed as well. We'll talk about how it's impacted administrative cases that employees have or want to bring, impact on pending reductions in force actions, and then back pay, which I know is kind of a hot topic because furloughed employees were not being paid during that time and they're owed back pay. And so we'll talk about any issues regarding that and any challenges that those employees could use to because of their back pay issues. So to get started, the federal government shutdown lasted 43 days. It was the longest shutdown in history. It ended about 2 weeks ago when the president signed that executive order. During that time, the administrative agencies that adjudicate federal employees' complaints were shut down as well. And those deadlines were stayed by the length of the shutdown. And no cases were being processed during that time frame. For federal courts, the federal courts did remain open, using available judiciary funds, but operated at a limited capacity. For those administrative cases, so it's important to note that the cases were the deadlines were stayed by the length of the shutdown, but those were deadlines that occurred during the shutdown. So if there were deadlines that were happening before the shutdown, those deadlines were not stayed. Now, for deadlines that were set after the shutdown, technically those weren't stayed, but judges have, at least with the MSPB, automatically extended those deadlines. With the EEOC, that's been more of a case-by-case basis, and judges have been issuing administrative orders, case management orders about what the deadlines are. But it's best to clarify whether you're before the EEOC, the MSPB, the deadline for the judge by contacting the judge and clarifying when a certain deadline is set, given the shutdown that's occurred. And that's similar with the OSC. If you filed an OSC claim before the shutdown and you're trying to track about when that investigation should be completed, just note that the shutdown may have impacted that investigation because OSC wasn't open. At least it wasn't open in full. So that investigation may be extended as well. But it's best to clarify with the investigator or the EEOC judge or MSPB judge about that deadline. Similar for federal courts, there were matters that were still suffering from delays. Specifically, if you had a matter against a federal government agency, then that federal government agency and its attorney was likely furloughed. So the courts on a variety of matters did issue notices that the cases were going to be stayed, postponed until the government reopened. So it's best in this matter as well, if your matter was stayed, to contact the U.S. District Court judge by filing a motion or whatnot to clarify the deadlines in your matter. But now that the government is reopened, these judges can be contacted and deadlines should be clarified, and just the status of the cases should be clarified if the judge hasn't stated so already. Let's see, impact of continuing resolution on federal employees. So the government reopened on November 13, 2025. It did restore funding through January 30th, 2026. So that means that, there could be a potential shutdown again if there isn't funding agreed upon by January 30th, 2026. The resolution did guarantee back pay for employees that were furloughed during this period. So there were, I know, questions regarding this during the shutdown about whether those employees would receive back pay. But the continuing resolution bill did guarantee back pay for those federal employees. Notably, this was under a act that was signed in 2019. There was a government shutdown in 2019, and there was an act, the Government Employee Fair Treatment Act, that was signed that guarantees back pay. So this bill guarantees that it's going to follow that act that was signed, and providing back pay for those furloughed employees. And again, we'll talk more about what back pay is for each employee is entitled to as well here in this webinar. Another notable piece of this continuing resolution was that employees who received a reduction in force during the shutdown are going to be rehired with back pay. That cancels more than 4,000 layoffs that occurred. And I believe OPM has issued guidance that those, as far as when those employees should be restored. This continuing resolution also said that there will not be further reductions in force between the date that this continuing resolution was signed and January 30th. So that kind of gives some safety net for federal employees to be safe as far as that, not being worried about getting a RIF action against them for at least the next couple months. And there was litigation going on about the RIFs that occurred, the reductions in force that occurred during the shutdown. And that litigation still exists, but that may be impacted, given that those reductions in force were reversed, somewhat rendering moot that litigation. Now, RIFs that happened prior to the shutdown were not impacted by this continuing resolution. So those RIFs are still ongoing, and those employees could still challenge those RIFs. We previously done several webinars on reduction in force. So if that's something that you have questions about, please look back at our webinars or call our firm about that. But for this continuing resolution that was signed, it reversed the RIF during the shutdown and stated that between the enactment and January 30th, there won't be funds used to initiate another RIF. So the EEOC hearings, as I was saying, that were scheduled to occur prior to or during the shutdown were canceled, and administrative judges are rescheduling on a case-by-case basis. So if you had a hearing or status conference that was set to occur October 1st, that more than likely did not happen, and that is being rescheduled by the judge. If you haven't had that rescheduled yet, I'd suggest contacting the judge to get that rescheduled. And that will really probably just depend on scheduling and availability of people. But the deadlines for completing discovery and submitting motions were also suspended. And in general, the EEOC did provide guidance that the shutdown, extended the deadlines by the length of the shutdown, 43 days. But administrative judges have discretion on modifying those deadlines. And I've seen that discretion on cases where I represented federal employees, where judges are not actually extending deadlines by the length of the shutdown. They're choosing a date that they think is sufficient. So if you feel like you need to clarify that with the judge, again, contact the judge for your EEOC case. Again, anything that was scheduled before the shutdown, was not impacted. But if it was impacted by the shutdown, again, just contact your administrative judge to reschedule. Similar info on the next slide with the Merit Systems Protection Board. The Merit Systems Protection Board, their e-appeal site was not operating, so you couldn't file MSPB appeals except by fax. Now, the Emeritus Protection Board did say that the extension is automatic and the extension by the length of the shutdown applies to all deadlines, including filing deadlines. So this is very important. If you received a removal, if you were removed in the month of September, or received an action that is appealable, such as the suspension or demotion, and your deadline was during October, even October 1st, I suggest filing your appeal now because your deadline was technically extended by the length of the shutdown, but you can now file your appeal given that the government is reopened. As far as other matters such as hearings that were scheduled during the shutdown, that were scheduled for during October during the shutdown, those are being rescheduled on a case-by-case basis as well. But those deadlines for the MSPB, they've been through an automatic extension. So I haven't seen as many administrative judges issuing orders or anything like that. I think they've been going by with the MSPB published, which was all deadlines are automatically extended. But if you're seeking any clarity, I would suggest filing a motion with the judge. Back pay for furloughed employees. So as I mentioned earlier, in 2019, the president signed the Government Employee Fair Treatment Act, which covered furloughed and accepted employees and ensured that employees would get retroactive pay when the shutdown ends. So for those furloughed employees were not paid during the shutdown, and then they weren't. But when the shutdown ends, those employees are supposed to be paid retroactively. Now I know this could lead to a number of questions about how much pay, but the OPM, and they've actually issued guidance, is that the employee is supposed to receive the pay that they were going to receive, but for the shutdown. So the basic rate of pay should be paid, and then also if there was overtime pay, allowances, differentials, premium pay, should also be paid as if the work were going to be performed. If you were an employee that was scheduled or planned to work overtime and was typically entitled to overtime pay, that would be paid as well. Now, if you were scheduled for non-pay status, if you were scheduled for leave without pay or whatnot, that's not going to be paid. That's not going to be converted to pay. But other notes here are that, accepted employee who had intermittent furlough periods is entitled to retroactive pay for furlough time as well, without being charged the paid leave. But the key concept here is that the employee gets paid their basic rate of pay because they would have worked but for the shutdown. That includes any additional pay that they would have received. The time period the employee spends in the position counts towards time and grade. So I know employees are looking to maybe have positions that are GS9, positions that are automatically converted to GS11 after a certain time and grade. You don't lose that time just because of the shutdown. That is counting towards the shutdown, towards your time and grade. Again, the goal of this act is to not harm the employee because of the shutdown, just because they were not working. That includes leave. That leave should have continued to accrue as well. That should be accrued for you as well. Now, for like employees that are on temporary or term appointments, that were scheduled to expire during the furlough period, now, the agency cannot extend those. The OPM has stated the agency cannot extend those term or temporary appointments. So those deadlines did remain. Those set time frames did remain despite of the shutdown. As far as like performance issues, so obviously performance evaluations are usually issued around this time frame, in October time frame. Those agencies have been advised to adjust the timelines and to ensure performance closeout activities so they could ensure that there's an accurate performance evaluation issued. If you hadn't gotten your performance evaluation issued, but it was due, but you had to complete certain projects or whatnot, the agency should try to adjust those timelines to ensure that those closeout activities are met. And like I said earlier, as far as retroactive pay, for the furlough period for retroactive pay is received is fully credible for retirement purposes. So if you are near retirement and you want to ensure that you're still being getting credit for retirement, that is the case, and it won't be considered leave without pay. So this furlough period should not be negatively impacting you as far as accruing time for retirement, accruing leave, accruing time and grade. So now with all that said, there could be issues that come up. If the pay that, for instance, you weren't paid your full overtime, you would have been paid. You weren't paid your full additional pay differential. You weren't paid. You do have a chance to appeal the furlough action. Now, a furlough is appealable. Now, it's actually, if you appeal it, it's actually going to be entitled as a RIF, a reduction in force, because it was over 23 days. But as we say on the screen, the federal regulations state that placement of employee in non-pay and non-duty status for more than 30 consecutive days or more than 22 work days is considered either a furlough or a RIF. If it's under 22 days, then it's a furlough. If it's over 22 days or 23 or more days, it's a RIF. Both actions are appealable. And the board, the MSPB, so when I say appealable, it could be appealed to the Merit Systems Protection Board. And the MSPB could overturn the action and award what's not provided if the impellant, the employee, shows that there was a harmful error. Now, it is it should be noted that these appeals become moot if it gets fully paid. So I always try to encourage employees before filing an appeal to try to work out with the agency to clarify and get the back pay instead of taking the time to file the appeal. But when that is being proven unsuccessful, you're not getting responses, you do have an avenue to try to challenge or raise these issues with the Merit Systems Protection Board. And there have been cases in the past where employees have had to take that action to have the MSPB overturn and correct the back pay awarded. So that is an overview of everything we wanted to cover as far as the impact of the shutdown and the continuing resolution and the back pay issues. I'll hold here for any questions.
One of them was, what would happen to a case if a MSPB AJ assigned to your case decided to retire due to the shutdown?
So that case should be reassigned. The MSPB can reassign cases to another administrative law judges and do so as quickly as possible to not interfere with the case processing. I know we had some pre-submitted questions. One was regarding how to handle requests for overtime or additional duties not clarified in the job description. I think this is relating to, I would suppose that this is relating to an employee that maybe had to work during the shutdown. At least that's how I could relate it to this. So that employee should be entitled to the pay so long as they're eligible for overtime and their position allows for overtime. And this question also speaks of relocation expenses. Now, if you were provided relocation expenses and your promised relocation expenses, they weren't paid, that's something you should certainly follow up with your agency over. You could also have an avenue of going to the Office of Personnel Management to file what's called like a pay action, disputing the pay that you were given or not given. So a question we just had, should my lawyer contact the MSPB administrative judge for rescheduling my hearing? Yes. If your hearing has yet to be rescheduled and it was supposed to be scheduled during the shutdown, I would suggest filing a notice with the judge to request rescheduling and providing the judge available dates. Now you would have to, it's best practice to speak with the government so you could have a joint notice to the judge saying, these are the available dates for the parties that we would prefer to have the rescheduled hearing. But in most cases, I've seen judges have already rescheduled hearings. But if that has yet to happen, given that it's been a couple of weeks, I do suggest making that notice. So another question we did submit that was submitted beforehand has to do with USERRA rights and submitting retroactive leave under USERRA. I would suggest contacting our firm because we handle USERRA matters because this is very specific to the situation, and we could work through this issue and whether to bring a USERRA action on your behalf. And I think we have our number here in the webinar on our last page here, so you'll be able to contact us to schedule that consultation. Okay, if we're not getting any other questions, then I guess we'll end here. But our contact information is on the screen. So please let me know, and please contact our firm for any case specific questions you have, or if you'd like to use our firm's assistance and any issues that have arisen from the government shutdown. But thank you all for joining.